So when do we get our slides back?
That's going to be right now.
Cool.
Fantastic. Okay. Oh, it was back. Okay. Excellent.
All right, so who the hell are these people who have been wasting your time for the last 10 minutes?
I'm Christy. I used to be an engineer. I worked for about 15 years as a network engineer, and then I got into hardware security for a while, and I decided to go to law school because that's where all the really interesting problems arise.
So I used to be a journalist. I worked for the Houston Press for about 5 years. Then I went off to grad school and studied linguistics and tripped and fell into computer security. And that's what I've been doing since then. So I'm the technical director for Fork the Law. Christy's our executive director, and TQ over there is our systems director. If you have any questions about what we're building on the back end, he can help with those. So what is this thing we're doing and why? If you've been following the recent issues involving gun control in the Senate and the bill that recently failed, Andy Kroll had an article in Mother Jones just 2 days, or yesterday actually, pointing out that one of the key things that led to the failure of this particular bill in the Senate was that the pro-gun lobby was able to rally more people to get in touch with their elected representatives than people who didn't have skin in the game. And this is just generally how it works. I mean, if you have skin in the game, you are motivated to get involved in the political process and make shit happen. This is how gay marriage happens.
More importantly than this, to raise the point raised in the back, what this results in is companies who are able to afford to hire full-time lobbyists wind up having a lot more ability to control what legislation gets written simply because they have the time to be there, to show up, to call, to continually engage representatives with their point of view, when what's happening is in the corporate interest but not public interest. The public interest doesn't have a representation because it's just the people, but that's who the law is supposed to represent anyway. So without lobbyists, you don't have the engagement that you would have if you just were a regular people who didn't, you weren't political. You don't want to put a lot of effort into the changing the law.
Yeah, and the weird thing about lobbyists is they're kind of a perverse incentive, right? I mean, if we had a perfect legal system, we wouldn't need lobbyists anymore. It's kind of the same way that, like, if
Legislative.
If we had a perfect legislative system, we wouldn't need lobbyists anymore. There just wouldn't be work for them, kind of the same way that, if we had, completely verified operating systems and network stacks, we wouldn't need pen testers. If you're a lobbyist, you always have some interest in keeping the system broken in the way that it's currently broken, because that system provides an incentive for you to have your job. And as Upton Sinclair famously said, it is impossible to convince a person of anything if their job depends on them not understanding it.
Furthermore, the really interesting part that we discovered in putting this effort together is that with the way these lobbyists, special interest groups, get money is through polarization. And this polarization occurs for the special interests, but what it's winding up doing is, over time, it's totally polarizing the news media, it's polarizing people's opinions, it's encouraging people to think in black and white terms, because that makes them money. And as long as there's money to hire lobbyists to write the legislation for you, then there will always be polarization occurring and people not coming together, people being divided by every issue there is.
And I think we can chalk part of that up to the way that the electoral system works, since we have a first past the post voting system, where whoever gets more votes, whoever gets the most votes wins, even if they only got 30% of the vote or whatever. Who here sort of Duverger's law? Duverger. Duverger was a French political scientist who observed the history of elections he did research into the history of elections for a couple hundred years and determined, on the basis of his empirical research, that when you have a first-past-the-post voting system, the Nash equilibrium was not the term he used, but essentially, the equilibrium state for this is a two-party system. If you have an Australian-style voting system, which is kind of like the one they use for the Hugo Awards. Well, no, just like ranked choice, for instance. The question is it first past the post, or is it ranked choice, where even if your first person doesn't win, with ranked choice you rank everybody on the ballot in terms of how much you want them, and so the winner is computed by the rankings. And when this happens, you tend to end up with a very multi-party system, and these both have problems. But having lived in a country with a multi-party system for the last 3 years, I've noticed that the failure state for that one, Belgium, the failure state for that one seems to be you just don't have a government for a while. This was actually okay. Like, Belgium spent most of 2009 and about half of 2010 with no government, and no one cared. The only point at which it mattered was like when they needed to get a budget passed.
Right.
Yeah. Most successful failed state in history. Anyway, so we've talked about some of the problems already. Can we recap those for the people that came in?
Right. For the people who came in, there's somebody advocating changing drug laws and
what the specific change?
Specifically decriminalizing drugs and dealing with it as a health problem as opposed to a criminal problem.
Right.
Help refresh my memory. There was
traffic laws.
Traffic laws,
making it easier for people for non-lawyers to help people fight traffic tickets.
Right.
We had the zoning thing with I don't know if is that technically
Metro
zoning?
fiber.
Yeah, the Metro fiber thing. Is that technically zoning?
No.
I'm not the lawyer. She is.
No, it's just a state statute.
Okay.
That is problematic and written by corporate interests, obviously. Then there was an issue of taking the money out of politics and bringing the people back into politics.
Florence Leslie would approve.
Am I missing anyone? Do you recall?
Did we miss anybody? And does anybody that came in late have anything any area of the law that they're particularly interested in changing? Yo.
I guess taking the teeth out of the DRM scheme, digital rights management.
Sweet.
Being able to, like, in my mind, if I buy a smartphone, it's my computer. I should be able to program it any way I want.
Okay.
So some of that Library of Congress has some flips over, but I think there are some court cases as well that say you're allowed to root your own phone.
So for the recording, that's dealing with anti-circumvention with the DMCA. That's one of the things we anticipated you guys would be interested in.
All right, so let's talk about the difference between statutory law and administrative law, because that's probably the most important takeaway that's going to come out of this. I'm really glad that you said that your interest in the drug laws is going from criminalization to decriminalization, because if we were talking about stuff like let's get marijuana off of Schedule 1, that's actually an administrative issue, which Christy is the person to explain.
Right. Statutory law and administrative law are back up a step. Okay. Congress is authorized under Article 1 of the Constitution to make laws that the executive branch executes. Well, there are a lot of issues where there need to be federal rules that Congress doesn't have the time or knowledge to create laws surrounding, such as TV, radio broadcasts. And so they have created a law that establishes an executive agency, and that agency in the statute that creates it is given the authority to make rules. And these rules can have the effect of law, but they're not changed in the same way because they're decided by the experts at the agency. So there's an entirely different process for doing that. Like, for example, in your example, the DEA creates the schedule that has marijuana on the schedule, However, their authorizing statute gives them the authority to decide what goes on the schedule. So, and it also criminalizes what is on the schedule. So if you just wanted to change what's on the schedule, then that's an administrative process. If you want to decriminalize all drugs, that is a legislative process,
Or even just to
or
even just to decriminalize, like, you know, if you wanted to say, like, we'll leave Schedule 1 like it is and we'll decriminalize 2 through 6 or whatever.
that becomes
would be
more problematic and
I don't know,
more complicated, because
would that not be statutory?
what's the definition of a schedule is probably still within the administrative agency.
So is it a good rule of thumb then to just not assume that statutes can reference administrative rules?
Right.
Okay.
Administrative rules don't work backwards necessarily to statutes. They just have to be authorized.
Okay, so one-way data flow there. So
Yes.
so if your goal is to, you know, get you know, environmental regulations changed, right? You know, so the Clean Air Act and the Clean Water Act authorize the existence of the EPA, the Environmental Protection Agency, and they authorize the EPA to you know, to make rules, but if you want to change something about the Clean Air Act or the Clean Water Act, you don't get to reference any of those rules.
Right. That's a process that you can actually work directly with the agency on. You can exert political pressure to get the agency to consider new rules, and or whatever pressure you might do, but it's entirely at their discretion. And so if they decide to issue new rules, they open a notice and comment period. You file your comments. Anyone can file comments. And then they consider the comments and they make the rules themselves. The only standard that they have for that is that the rules not be arbitrary and capricious.
I guess really the main difference then between like statutory and administrative law for our purposes is that with statutory law, your end goal is to convince half of Congress that that this new bill is a good idea, whereas with administrative law, you don't really know who you're going to have to talk to or who actually has the decision-making authority.
Well, actually, it's fairly easy to find out. Yeah, it involves. It's actually a little easier to
Look
change.
at the State Department, though. Like, look at all the shit the State Department does that the Secretary of State has no idea about. So, yeah, some other examples of agencies include the Food and Drug Administration, who deal with pharmaceutical drugs rather than illegal drugs. We mentioned the FCC already. Right. You know, and a lot of these agencies, you know, there are a lot of regulatory agencies that have sprung up and been closed down, both by statutory authority. Like, how did the Railroad Commission die?
The Railroad Commission's got folded into the TSA, I believe.
Oh, okay.
Homeland
All right.
Security.
And that would have been a statutory thing, right?
Yeah.
Okay.
Yeah.
Okay, so we've got brand new people. Cool. You've just walked in on the end of the introduction. Did you come here with something you were particularly interested in wanting to change about the law? If so, please tell us. Not particularly. Okay, that's fine. Okay. So, once you have some idea of what it is you're interested in changing, then you have to find the exact part of the law that, part or parts actually of the law that relate to it and will need changing.
If you have your laptop, now would be a good time to follow along. We created an Etherpad with links to some of these things. We didn't put a link on here without giving you the ability to follow it without having to type it out. So if you go to what is that link?
forkthelaw.etherpad.mozilla.org.
Right.
And then sign in with.
You don't have to sign in.
Oh, you don't?
I made this one public.
Okay. Well, I'll sign in.
And it's /7, I believe. /7. You have your pointer in the wrong place. People can't see the URL. Okay. So forkthelaw, etherpad.mozilla.org/7. And we have the link right here for the U.S. code. the way this is generated, US code, if you want to follow that link since you're in the browser anyway.
Okay.
The way US code, it's separated into titles. So for your anti-circumvention issues, we have copyrights. And for food and drugs, we have Title 41.
21.
21, thank you. It's been an adventure lately.
Well, that would be.
And
would the question about decriminalizing drugs be under food and drugs or under intoxicating liquors?
I believe it is food and drugs.
Okay.
And 18 USC 1030? Or yeah.
Yeah, we'll pop that open for the
Yeah.
CFA.
18 USC 1030 is one I have in my mind because that's the Computer Fraud and Abuse Act. Computer Fraud and Abuse Act is what kind of started us down this path. Perhaps well, obviously you know about the death of Aaron Swartz and what he was prosecuted for. There are a lot of information security professionals who are really up in arms about this. We're actually talking with a major certifying organization for information security professionals, ISC2, about their interests in changing the law or reinterpreting the law at least, because it criminalizes behavior that makes our computer networks more secure. So these are just like chapters in a book. And you can drill down, and you've drilled down.
Yeah, I drilled down all the way to 18 USC 1030. But if you look at the, if you look down at just the title, so there's crimes, and then there's an appendix, and so you've got chapters relating to all different kinds of things. So we've got like arson, assault,
civil rights. This is where we start talking about the 14th Amendment stuff and people's rights and exactly what civil rights violations are crimes.
Yeah, coins and currency, that's going to be like forgery.
Right.
Embezzlement, espionage, extortion.
The way this gets updated is Congress goes through and passes legislation which says this is a crime. It doesn't fit this chapter numbering system, but there's an office within Congress that figures out where it belongs and sticks it in that chapter. So when you update bills, like we want to change the Computer Fraud and Abuse Act, we go through this and we post, change this to this. And so it effectively becomes a diff from what you want the law, or what the law currently is, to what you want the law to be. So,
yeah. And currently, finding the specific section of the law that relates to an interest is not necessarily easy. Like, it's not obvious from the title of, for instance, Chapter 47, Fraud and False Statements, that's where that's where computer crime law would be.
It is called the Computer Fraud.
It is called the Computer Fraud and Abuse Act, but if you didn't know that beforehand, it would be hard to find it. We're actually building out a web application to make it a lot easier to find all of this information in the first place. We're using the U.S. code as a data source. We're using federal regulations as another data source, case law as a third data source. And we're mashing that up together with full text indexing and like natural language processing food just to make this shit easier to find. But that code is not done yet.
So our goal is to make it so that you don't need a full legal education in order to understand the law.
Yeah, you should not have to have a freaking law degree to be able to find the...
And to suggest changes. One of the big problems with the Computer Fraud and Abuse Act is it's written by people who have some vague knowledge of computer security. I've talked with Zoe Lofgren's administrative or legislative assistants, and they're very technically savvy, but they're technical knowledge is very broad necessarily. She has two people who have technical knowledge, and they don't have specialized security knowledge and specialized other knowledge on copyrights and knowledge on all telecommunications and all the other things that go into technology. It's a huge field, and so they just have, and on top of their law degrees, by the way, these are both lawyers I'm talking about. So so they have a very broad understanding, and so what we're trying to do is take away the need for that law background and make it accessible to people who are experts in other fields, in very specific technical fields, so that we can get input without having to rely on lobbyists who are speaking for organizations.
I just want to add something to that real quickly. So after ShmooCon back in February, Christy and I got about 12 people together to go to Congress.
It was before ShmooCon.
Oh, sorry. Well, yeah, sorry, before ShmooCon, my bad.
Adjacent to.
Adjacent to ShmooCon, yeah. So we literally just grabbed a dozen people and showed the fuck up. We didn't make appointments. Like we were all really like, we didn't know what the hell we were doing. We were like, let's try this and throw it at the wall and see if it works. So we ended up splitting up into two groups and just visiting everybody's representatives in order. And we got kind of blown off at some places and had some really great conversations at other places. And one of the really valuable conversations that we had was actually at Representative Sam Farr's office. We got a few minutes to talk with the legislative assistant of his who handles...
Chief of Staff.
No, that was Rangel.
Oh, okay.
I'm talking about Farr.
Okay.
So the legislative assistant who deals with computer-related issues for Sam Farr, it was actually Nick Farr that was talking about. We visited Sam Farr's office because they've got the same last name, and Nick occasionally gets emails from Sam Farr. The legislative assistant, lets him get about 3 sentences in, and then is like, "Oh yeah, I'm familiar with this. We usually take our lead from Anna Ishu's office on this." And at the time, I was just kind of like, but it should have been kind of obvious, it was a lot more obvious in retrospect. It's kind of this is normal human behavior. When people are not experts on things, they defer to other experts. And unfortunately, in Congress, people can be perceived as experts even if they don't know jack shit about something.
Well, Anna Eshoo is a representative from Silicon Valley.
Right.
Her district abuts Zoe Lofgren's, and probably the only reason they don't ask about Zoe Lofgren is because Zoe Lofgren's very vocal about supporting very specific things that not everybody gets on board with.
Yeah, but I mean, this is a really big problem. Particularly when the person who's kind of viewed as the expert is really ignorant. Like Mike Rogers, the guy that floated CISPA in the House just a couple days ago. Turns out his wife is running a company that gets lots of government money for doing cybersecurity stuff, and he's managed to position himself as an expert basically on the basis of her work. And so now we have to deal with fighting CISPA in the Senate because nepotism.
He thinks he knows enough to write legislation.
But anyway, the cool thing is that once you make if you can make a personal connection to somebody in your representative's office, and usually that will be the legislative assistant who deals with the issue that you're interested in. Once you're in contact with that person and keep in contact with that person, continue to update them as the landscape changes, as the stuff you're doing changes, they'll start to pay attention to you. It's really just all about developing that relationship, and it does not have to be a full-time job. We don't want this to be a full-time job. I have a full-time job. I'm doing this part-time on purpose because if I had two full-time, well, I already have two full-time jobs actually. If I had a third one, I'd probably kill myself.
More than that, there's a lot of talk about the Washington bubble. The Washington bubble is very, very real because people who make it their full-time jobs wind up talking to other people who have made it their full-time jobs, and it becomes very much a closed network. And so you're no longer working your day job and making the connections to the people and keeping up with the technology and the issues surrounding the technology. So there might be people who have worked in the industry in the past who've lost touch. They kind of know who was big back then, but there's no way to tell the Gregory D. Evanses from the Dan Kaminskis.
Yes?
I don't want to hijack your talking about, but you brought up a subject that I continually think about, like, what keeps Senate and Congress sessions from like being like digital sessions? Why can't we have more like Skype sessions, if you will, where they don't have to be in Washington D.C. or whatever legislative building all the time? Why can't they live like full-time jobs and do their work on a part-time basis?
One of the really important roles of congressmen is negotiation and working out support amongst other congressmen for their bills. So it's as important for the hallway track as it is for the actual sessions. I think that's the number one reason.
In practice, I totally think that could work. I
Yeah.
mean, I'm kind of sitting here racking my brain, going, have I seen have I seen a congressional testimony session where somebody was telepresenced in, like to, in order to speak to Congress? Because that happens. Prior to a couple of weeks before the CISPA vote, there was a pretty big. What's the term I'm looking for? I'm sorry, the word totally fell out of my head.
Hearing?
Hearing, yes. that Orrin Kerr, for instance, was part of, but he had to physically be there.
Mm-hmm. There's also the issue of security and bandwidth and other things like that. I know I personally would not want, based on the level of security that they've designed other systems around, I wouldn't want Congress votes traversing the internet. That thought scares me quite a lot.
Understandable. But you've got a good point. I mean,
yeah.
Representatives have offices in their home districts for a reason. It is part of a representative's job it is a representative's job to represent their constituency, the people that live in their district. So
that's why Congress has the light schedule that so many people keep criticizing, is because they need to have that time off to go back home and talk to their constituents. Unfortunately, their constituents that they talk to back home are also typically lobbyists.
Tend to be lobbyists. But the good news about them having a home office is that you don't have to travel to visit them, or at least you don't have to travel very far, unless you live someplace really rural.
Anyone can request an audience with their representatives. Senators, it's a lot harder to get to see, depending on the size of your state. But I'm from California, where we have millions.
Yeah, and I'm from Texas, where we also have scads of them. But it's really not hard. I mean, the first time I called my representative for an appointment to talk about an issue I cared about, I was actually too young to vote. All right. So, once you've found the portion of the U.S. code that you're interested in changing, the next step, we're kind of skipping over the step where you figure out the changes you want to make. But once you have changed it, go ahead.
Oh well, no, you were talking about GovTrack.
Yeah, well, finding the reps and senators.
Yeah, this is a really messy problem right now. Finding the reps and senators, it's complicated because what you need to do is find the legislative history. Thomas.gov, looking in multiple Congresses to find exactly the statutes, because the statute doesn't map to the bill on a 1-to-1 ratio. Like, for example, the DMCA anti-circumvention, DMCA actually has 15 different sections of code that it changes. It's really, really pretty extensive. And so you want to go back and find the DMCA and find the committee it was introduced through. And that committee tells you the likely representatives and senators that you want to talk to. It's a lot more successful. A bill will be a lot more successful if it's introduced through, say, the Computer Fraud and Abuse Act is introduced through the Judiciary Committee because it's a criminal statute, and the Judiciary Committee is tasked with evaluating criminal statutes. Occasionally, very rarely, a bill that has widespread support already can be introduced directly to the Congress. This is not likely on anything you or I would be able to do because it requires such broad support across the board to begin with that it's almost impossible to have it introduced directly. So you want to find the committee who is supposed to be more knowledgeable in that area of law. What are we looking at here?
Oh, I figured I would pull up an example of like what the diff looks like.
Oh, right.
Yeah.
Go back to the first page.
Sure.
Okay. Yes. This is Zoe-Lofgren.
This is actually the first draft of Aaron's Law. It's not the better, more recent draft, but it's also simpler.
Yeah, a discussion draft, and so it was referred to committee on this date. If it's introduced to the committee, then it'll be referred to the committee when it's introduced. If it's introduced to the floor and then referred to the committee, somebody in the committee has to like it already, which you might as well introduce it to the committee anyway.
Yeah, and not every bill even gets referred to committee. If you look at GovTrack and look at their recent bills section and just click on some of the ones that have passed, you'll notice that a lot of them don't ever say that they were referred to a committee. Let me show you what that looks like, actually. Come on. All right, what is the problem? Okay. Exit full screen, sorry. Let's go to Thomas first. No, actually, let's go to GovTrack first. So this is GovTrack, which is a really neat project that's been going on for a while that automatically pulls in everything from Thomas, which is maintained by the Library of Congress. So here's an example of a bill that actually that never went into committee. It was a financial disclosure related bill.
This one.
Yeah.
Yeah. This one is a really interesting one. The idea was there was an outcry over insider trading within Congress, and so they passed this they passed a law saying that Congress couldn't do insider trading and made the public happy, and then they decided, we really want to do insider trading, so let's pass a law real quick that nobody notices while they're up in arms about arms control or gun control, and let's get in quickly the thing that totally guts the insider trading restrictions that Congress has.
So you'll see here that it had no co-sponsors, and there's not even an entry for committee. And if you look at the primary source on Thomas, you'll see that yes, in fact, there were no co-sponsors. It was not referred to committee. However, another bill like I think the appropriations one got referred to committee. Yeah. So for instance, this
always has to get.
like so this appropriations bill went to the House Appropriations Committee and the House Budget Committee, and Thomas indeed indicates just the same. And you can actually on Thomas you can look at other things that that committee has done. But primarily the important thing here is find out who you have to target.
Right. So back to our presentation.
Yep. Okay, articles and commentary.
Okay, so you know who you're talking to. You need to get started talking to them as soon as you have the idea you want to change the law. You don't even have a vague idea of how it needs to change. Like the conversation we had in here, because it's a long process to convince them. Nobody will agree to anything immediately. It's Zoe Lofgren loses a lot of bargaining power because she's like, bam, I'm on top of it. I have draft legislation here. People don't take her seriously as a result. So they need to ponder things and consider, like Darrell Issa, who is Republican proponent of an open internet, hasn't come out in favor of CFAA reform because he's referred it to a research committee. And he can't say anything until that research committee comes back with anything, or he'd be judged hasty too and lose a lot of bargaining power. So, on to articles and commentary.
Well, hold on, just something I wanted to interject there. The other reason to start having these conversations early is that if it helps you to develop that personal relationship that I was talking about, and people will help you brainstorm. The first office that my group visited before ShmooCon was Chuck Rangel's office. And we ended up having about a half-hour sit-down with his chief of staff, George Henry. And we told him about what our concerns were with regard to computer security, because we were specifically there to talk about the CFAA. And he actually brought up a couple of areas that we hadn't hit on very hard, but that he knew were important to the representative that he works for. So he brought up cars and healthcare as other examples of sort of problem domains that the CFAA can have a bad effect on. Right. So. You have to listen to people to find out what they want, and start
work
that conversation
in.
early.
And like my discussions with Zoe Lofgren included, well, we need change, but if you push for too much change at once, you'll get nothing. So you need to start talking about how can you pare this down, how can you make it a minimal change to get moving forward. And so we've been considering that. So the next step up is you find what all the legal pros have said about it, because there are people who just sit around and think about this shit. And so the idea that there's law students and law professors writing about it, you probably need to consider what they have to say, but kind of back in keeping with the idea that you're not a legal professional yourself and you don't want to be. We're trying to figure out how to pair law students who read legalese and want to get engaged with the discussion into translating it into human language. I have a list there of open access law journals. I find it really kind of interesting that so many law schools have moved to an open access model. Law schools, these are lawyers, that you think their intellectual property is more valuable than others. They're publishing open access. So
if you can get access to Westlaw or to LexisNexis, those are fabulous.
They're fabulous, but outrageously expensive, and I don't really want to discuss them a lot.
No, I don't want to discuss them a lot. I don't want to discuss them a lot, but I do want to point out that you can usually just walk into a law library and
no, you can't.
Really? Because you could totally do that at U of H.
You can in Cleveland State.
Okay. In California, there is one law library you can walk into as a person, and the librarians won't help you because the issue the gentleman raised in the back. Oh, you raised it, yes. Because law librarians have been sued for helping people research law. So it's terribly frustrating circumstance. But those lawsuits have occurred, and it didn't used to be that way, but because individuals are litigious, then it's kind of broken down in a lot of unfortunate ways.
At Cleveland State, APC Euclid, walk in, it's open pretty late, free parking in front, and they'll let you through all the books
Right.
Librarians have been pretty good.
Right.
So
Yeah.
Here it's good.
Some libraries will even have just access to Lexis, even if they're not a law library.
Nice.
Yeah, we had LexisNexis at the Houston Press because the investigative reporters used it. So if you have a friend who's a journalist, they may be able to hook you up too. But that said, open access, it's a thing.
Yes. The real value in these outrageously expensive databases is that they digest the law. Even when lawyers research, they don't read all these cases. They don't summarize for you. They read somebody else's summary. But that's why they're expensive, is because lawyers are hired.
You know, automated
to digest
summarization
these.
is also a thing.
That would be interesting. Yes.
We could try that. I don't know how well that would work. but we could
I am
try
all for finding a technical solution to hairy legal problems. So the idea, the idea is it's really interesting. Also, press articles help because things that the EFF publish help.
Articles in the newspaper and
they've had the benefit
and
of,
major online news sources. They just they've number one, they've already done their homework, which is what I think you were about to say. But number two, they also show that there is support for your issue.
So that's all useful to take into consideration when changing the law. Then also case law. You never know how a judge is going to interpret things. Legalese is fascinating to learn because words like consideration don't mean what you think they mean.
And people have long debates over what the word "the" means. No, this happened.
Or misplaced. No, it has happened. A comma. That comma there has. There was somebody arguing in front of the Supreme Court about a previous Supreme Court decision, and one of the justices pointed out that he had penned that decision, and I said, I put that comma there for a reason, that is a dependent clause, and you find justices arguing grammar.
There was another thing recently, though, where a comma actually made, where I think it was a state law issue. I can't. Do you remember the thing I'm talking about? No, but it was a punctuation thing, an actually misplaced comma made the passed bill ineffective.
Right. So the judicial interpretation of things is really fascinating to go through because it kind of interprets legalese or reinterprets the English language depending on your perspective, and so going through. A Supreme Court makes a lot of clarification issues, like are you required to have a warrant for attaching a GPS device to someone's car? That was a recent Supreme Court decision.
And the Supreme Court is really the ultimate law of the land.
Right.
I don't know if anybody remembers the Military Commissions Act from 2006. It was passed about halfway through the Iraq War. And it was a bill that established the judicial authority for trying unlawful enemy combatants. That was the term they used. And one of the provisions in this law was that the only appellate court that was acceptable was the appellate that you could use if you were appealing a case out of one of these military commissions was the District of D.C. And that, furthermore, it could not be escalated to the Supreme Court. And the Supreme Court said, whoa there, fuck you guys. You do not get to say that in a law. Congress passed it, and the Supreme Court said, go to hell.
Yeah, the Supreme Court says, no, we get to participate. You can't cut us out of the game. That's a classic. We have three houses of power for a very good reason. Yeah?
Comma story. You want a comma story?
Comma story.
Statute in the city of Cleveland is that you are not allowed, you might remember this one, you're not allowed to sleep on a park bench. In Cleveland, under statute, you cannot sleep on a park bench, comma, in a public park, comma, or some other places that I don't remember, except they left out the first comma. So it reads, you cannot sleep on a bench in a public park.
But you can sleep on a bench at a bus station.
Yes, and you can sleep in a public park as long as you're not on a bench. And people have actually used this, and I think there's case law on that, yeah.
That's
Yeah.
beautiful.
Yeah, that's funny.
That is beautiful.
Yes.
That's a great example. I think I'm going to steal
Yeah.
it.
Bus stops have very uncomfortable benches.
Yes.
All right, so appellate cases.
Appellate cases, this is where it gets interesting because this is where we wind up with different law across the country. Perhaps those of you who've been following the CFAA announcements, how it's a felony if you're between 13 and 18 to read the New York Times. And well, a felony if you're less than 13, but that's a separate issue. And it's a felony for 17-year-olds to read the 17 Magazine's website. That's not true throughout the country.
This is what we call a circuit split.
Yes, circuit split. In the Ninth Circuit, where California and Oregon, it's the humongous circuit, they decided that a violation of terms of service is not within the scope of unauthorized access, that through complicated process establishes a felony.
Was that U.S. versus Drew?
I don't remember the case law.
Because U.S. versus Drew actually went to SCOTUS, as I recall.
No, then.
Oh, it didn't?
No,
Okay.
this has not gone to SCOTUS.
Okay.
It's on the page that I asked TQ to restore for me. But anyway, so appellate courts, the split, and it's definitely illegal in some jurisdictions. Missouri, I think or the Seventh Circuit, Chicago, I can't remember the middle states. They don't have as many states per circuit as we do in the Ninth. They decided in the MySpace, fake MySpace page.
That was U.S. versus Drew.
Where the that did not go to SCOTUS.
Oh, it didn't? Okay,
No.
my bad. I thought
No.
it did.
No, but the idea is that the by creating a fake MySpace page, violating their terms of service, that's not a felony. And that was decided because they were looking for anything to prosecute these horrible people. Yeah, they were horrible people, but they made a fake Facebook page. That's like,
It's kind of like Weave. I mean, he's a terrible person, but he also accessed a publicly available URL a couple of million times.
So district court cases are interesting if you're looking for exactly what words mean, but not really much else because they're very narrowly focused. Like their Northern District of California is where all the Silicon Valley cases are tried, but they aren't binding for anywhere except in that small district court. And state court cases occasionally. We're looking at federal law here, and every state has a similar Supreme Court appellate. Actually,
Louisiana is weird.
New York calls it the Supreme Appellate Court, or the something appellate court. So a little different names, but you have these three parallels. For federal law, interpreting federal law, the state court doesn't really, it's not binding precedent. And often state courts will interpret things differently. It's possible to appeal to federal, it would jump from the state to appellate level at the federal level. If it's a genuine federal question, then they can do that. But if it's tried in state court with a federal question, it means that everybody's okay with the state court deciding, which means they're okay with not having binding precedent.
So that would be state court. That would be like state district, state appellate, state supreme appellate, and then federal appellate, right?
It might go from state district or superior court.
Superior, okay.
As California, everybody has different names. They're about the courts are all about hierarchy. So if something is not appealed, by the way, everybody has a right to an appeal. If a case is not appealed and not heard at the appellate level, it means that it wasn't important anyway. And they will, I won't say that it wasn't important, it was that they weren't willing to spend the resources, because it's expensive to appeal.
And of course, state court decisions are hugely important for state issues like the fiber one you brought up.
Right, and practicing law without a license is entirely a state court issue.
Yeah, it's going to be
as well.
a state issue too. Okay, so once you've got all of this information in front of you, then you have to make sense of it all.
Okay, this is where the law student come in. Law students are really interesting animals. They can't commit to a lot of time, but they're really excited about certain things, and they want to have their fingers in the ability to practice. The idea is they also can get charged with, in fact, law students are even more concerned than ordinary people about practicing law without a license, but they're also more informed that they can't, or what they can and can't tell you. Like, I can tell you how the law works. I can tell you in general terms what the law means, but as a law student, I cannot give you specific advice on your legal problem. I can give you general advice. I can point you where to look to see what other people's general advice is, etc. So law students, however, can explain cases. Well, this case means this, and that case means that. So this statute has been interpreted this way. Like the unauthorized access portion of the CFAA, there is more written on that. There's more case law. What does unauthorized access mean? One of the things that most computer security professionals I speak with on the issue are really surprised about is protected computer means protected by the statute, not actually protected by any technical means. Mm-hmm. And they are really surprised at that. And so there's not a lot of case law on that, but it becomes very clear when you start thinking about how the statute is applied that there is no requirement that the computer have any protection at all. So, so that's kind of one of the interesting quirks about translating it into plain English. Then looking at the court's interpretation and figuring out and identifying exactly what is wrong with this court decision and why this court decision is terrible. All the 17-year-olds should go to jail because they read the New York Times. I believe they changed the terms of service. As an interesting quirk, kind of going back to contract law, the reason most websites do that is because people under 18 cannot form a binding contract. If they make a contract, they agree to the terms of service on the website, and they go and they do something and they violate the terms of service, then they say, well, I didn't mean that. And the contract is null and void. They're not responsible for anything they did, et cetera. So they say, if you're 17, you can't access this site to get around the not being able to hold people contractually liable, which it does pose a really interesting conundrum.
It's just a bizarrely perverse incentive, though. I mean, in what universe is it better to send to put minors at risk of incarceration because they violated a click-through agreement? Yeah.
Right.
I mean, we have rules for breach of contract. There is law about that.
Yeah, and there's also issues surrounding people accessing their Facebook page from their work computer, and they agreed with their employer that they wouldn't use their work computer for personal use. And so there have actually been cases where the employer fires somebody for gambling or porn or something, and on the basis of that agreement, and they seek criminal penalties. And I think that's where the circuit split is formed. I can't remember the other side of the split.
But the point being, where you see bad outcomes happening, where you see people getting put in, sent to prison or fined for really stupid reasons, that's a sniff test for this needs to be changed.
And judges, I was warned when I started law school that judges really are the least technical people in the business.
Except for that one guy in the Ninth Circuit.
Yeah, he was selected for the Oracle Google case for a very good reason. he could actually code. He didn't reveal this to anybody involved in the case
It came up. It came up
until
though.
well later after everybody had presented their primary arguments and Oracle was going back, and they had come up with the 8 lines of code. And
Yeah, like they were trying to claim that like one particular API call was was protected, and it was just a really
under
simple.
copyright law.
Well, they were saying one particular API call in the Java API was protected under copyright law, and it was I forget which function it was, but. Oh right, yeah, and so the guy and so the actual judge was like, I have written more of these in my lifetime than anybody should ever have to. How can this possibly be something that can be protected under copyright?
Well, actually, he
Everyone
said
has to do
I
it."
could have written that last night in my free time, which is really saying something because judges don't have free time.
Based on judicial notice there.
I'm sorry?
That's not evidence before the court, though.
Well, it's there's a judicial stipulation, and I would be willing to say that would be judicial stipulation, and it's kind of impressive when a judge can stipulate code, computer code.
We done with this one?
Yeah.
Actually, I think we're done with our slides.
Oh, great. Okay.
Yeah, so we've got about 45, 50 minutes left. So
We'd kind of been bouncing back and forth between 1 hour and 2 hours for this talk, so.
But the way I see it, we've got a pretty small group of people, a pretty well-defined set of issues. I'm thinking now would be a good time to break out and start doing research. If y'all are interested in continuing with that, Christy and I can wander around and help y'all find information that you need.
Do you want to get started?
Who's up for it? All right, we got one guy. We can totally help you. Drugs? You want to stick around?
Yeah. No, I'm really interested in,
No, this
approach.
is something I personally care about a lot. I would love to see federal decriminalization. That would be awesome.
Yeah.
He suggested he's interested in decriminalization of illegal drugs. So, and that is actually a problem that can be tackled at the statutory level rather than at the administrative level. Because he's not talking about taking stuff off the schedule, which is an administrative problem. He's talking about just decriminalizing, which is a statutory thing.
That does bring up an interesting point with Colorado and Washington, where there's conflict between
State and federal.
Oh yeah.
Yeah.
What are your
California's been facing this with the prescription cards for years. And it's back and forth. There was some discussion about the president gave an executive order that this is a low priority for enforcement, but still some of the larger dispensaries in California have been shut down by the federal government.
I think there's been DEA raids in Humboldt too.
Mostly it's a focus on keeping the operations small, and which I'm not entirely opposed to. Anybody grows too big, they run the risk of becoming an industry. And
I'm okay with people who break into abandoned houses and abandoned or empty houses and set up their grow shop there. Like I'm okay with them being prosecuted for trespassing, but yeah.
Yeah. So it's an enforcement issue at that point, and if the DEA is willing to, mostly what winds up happening is the feet on the ground are the people who do the vast majority of prosecutions for drug-related offenses are small-time drug-related offenses are local police forces, and so the people who are working for the local police forces aren't going to get involved. One of the really important things to notice is, and it kind of came up in why they kept prosecuting Aaron Schwartz even after they realized that he's just a kid who's doing, research for whatever purpose, was that they had already invested a great deal of money and time into the investigation, so they wanted a conviction.
Oh, sunk cost fallacy.
Right, but the idea is at the federal level, you get federal prosecutors involved very early on in investigation. So they want a felony conviction out of that. So if they can't get a felony conviction for drug-related offenses, then they're not going to deal with it. The state and local level, they're not going to deal with it. And so it's all kind of swept under the rug. I think in the near future, that's going to be more of a problem.
Yeah, I mean, because given that the state of Colorado, I'm trying to remember, was it Colorado or Washington or both of them that like gave the state or that gave like police and sheriffs basically the authority to defend.
That sounds like Colorado.
I think it was, but yeah, I mean, like, what's going to happen, right, when the DEA decides to come in and do a raid, and and some Colorado sheriff shows up and says, yeah, that's going to be a weird standoff if that ever happens.
Yeah, California has managed to avoid that because they have tags and they have cooperatives where you can only grow so much for medicinal use. And limiting size deliberately that way, whereas the total decriminalization means that anybody can grow as much as they want, and so that might raise a bunch of different kinds of questions than California's faced. So, exciting stuff. So,
I guess the simple answer to your question is the disappointing answer of everything goes out the window when the guns show up.
Yeah. But the guns don't show up unless they think they can get a felony out of it, a serious felony.
Yeah.
So
how much are they willing to commit?
So to kind of get back to the representation without, or the practicing law without a license problem, that's an interesting line to walk. I kind of wanted to bring that up because
what area of the law actually covers that? Licensing, obviously.
It's professional licensing.
Okay.
It's.
Is that statutory?
Oh yeah, totally.
Okay, cool.
Yeah, the American Bar Association, in conjunction with all the various state bars, because licensing as an attorney is done on a state-by-state basis. So that's all state law, along with a licensure code.
For a minor misdemeanor, and
yeah.
The reason why I see this as a problem is, one, it takes away my fun. The other reason it's a problem is if you got a harassing citation, or you happen to live near a stop sign trap or something crazy like that, if you just get a traffic ticket that, it's a minor misdemeanor, it's 2 points in Ohio, you're probably going to end up paying $170 in fine and court costs, and your insurance is going to go up, which is really expensive, but it's not cost effective to pay a lawyer.
Mm-hmm.
Yeah.
And most people aren't very well equipped to fight it on evidentiary grounds or procedural grounds, so they end up just having to pay it.
And then Ohio is also doing that bullshit now where, like, if you have an outstanding debt, including a fine, you can actually go to jail for it.
You can go to debtor's prison for a ticket. Yeah, is that great? So people are stuck in the in-between area where I'd really like to say, oh, you should totally go to such-and-so lawyer, and it'd be great, and it's going to cost you $500 to deal with the $120 ticket. Doesn't make it,
But insurance, it's worth it. The insurance,
if you have the $500 right there.
Exactly.
And it also costs, and it means that getting pulled over costs you around $170. Getting pulled over and being wrong doesn't matter. Getting pulled over costs you around $170, at least plus your insurance change. In other words, you can't really win.
Right.
And I like there to be a way that people can actually win. So that's what I see as being the problem. You lose even if you win.
Yeah.
You're saying it'll cost you $150. I just recently paid $800 for a broken taillight ticket, and the taillight wasn't even broken. It was just cracked, and you could see white light coming from the rear light. But paid the ticket. They claimed they never got it, sent all the information to the wrong address. 3 months later, I found I had a warrant for my arrest for not showing up to court, all this stuff. Went down, paid like $300, straightened it all out, right? 6 months later, I get pulled over by a cop that was scanning license plates. And, well, he's like, I'm taking your license. Apparently, this is still not active. So I had to hire a lawyer, $300. But the lawyer looked through my stuff and said, oh, you got 3 notices here saying that everything's been fixed and everything's good. But yet, since the counties, depending on what county you go through, they don't update their databases. So technically, somewhere in like Ohio's or other states, I'm still known as the taillight bandit. And I might actually have to pay a lawyer to go all through this all over again.
Yeah, I've had all sorts of fun issues. Like I've had to appear in traffic court twice for the same issue. I was stopped for having expired registration and no inspection sticker on my car. Well, they just changed the law so that brand new cars didn't require the inspection sticker, and they transferred the plates to from my old car, my trade-in, but I didn't realize that those plates had expired because I hadn't been driving that car. So I renewed the registration, got everything fixed, and I got a letter from the dealer from the state saying the inspection sticker wasn't needed. And so I brought that into court and said, congratulations, new law, charges dismissed. And so I left. And several years later, I'm 2 blocks from my house. I get stopped, and I think some other issue had come up, like a taillight out or something. And they ran my license and said, oh, there's a warrant for your arrest in Brentwood. And because the cops in my neighborhood are decent people, they were really nice about it. But,
Meredith?
Yo.
Yes, it's section 4705.
Oh.
.07.
Cool. Yeah, I figured I would just start looking while she was talking.
Yeah. So yeah, I got to appear twice. This is not double jeopardy and I wound up only having to pay $10 for the original expired tags ticket that had been fixed. But the idea that the records are terrible is yeah, I didn't have to pay for the citation of not
And the thing
not
is,
appearing and not
and you could
having
do that for you, but you can't do that for anyone else.
Yeah, so I've got the statute up now. It's 470507, unauthorized practice.
And actually here, this is really interesting. If I hypothetically, or you as a student or anybody, goes with your friend to traffic court and speaks to, and speaks for that person in court and maybe examines witnesses, that sort of thing, you're not wrong until Part C, that's right, Part 3, because if you don't say you're a lawyer and if you don't say you're authorized to practice law, you're in the clear. It's only Part 3 where the Ohio Supreme Court says you can't advocate at trial.
Oh shit! So do you have to
So it's a regulatory
all of the Supreme
thing.
Court materials and find everything that the Supreme Court has?
Yes, you have to go to the Supreme Court rules
rules
on what they
rules.
define.
Yeah.
Supreme Court rules on what's defined as unauthorized practice. You could theoretically have this fixed by working with the Ohio Supreme Court to change the rule. It's not really statutory anymore.
Right.
Okay.
Yeah, that's another
So that would be
issue.
a second way to attack that would be
Yes.
the administrative route, or you could just, or I would say if you could figure out a way to reword that subsection A3 in a way that would, because that would be a pretty simple change if you can figure out how to reword that.
Comma, except in a minor misdemeanor.
Yeah, that would be very simple.
Yeah. Rules of court are a bit of law that are really weird. Law students study them in like civil procedure, criminal procedure, appellate law, and evidence. These are the ones that I've looked at thus far. But they're all just books of code that the courts decide for themselves. And there's no input, and they don't like input from anybody else because it's the court's interests. And mostly with the idea that they keep things fair, but we're talking about judges here. Judges judge. And so they have strong opinions. That's their job. As a lawyer, you're not allowed to have an opinion. You're just allowed to make arguments. And so the opinion is
So we found the section that's relevant because he already knew it. So my next question is who to talk to about it. So these are the standing committees
right.
of the Ohio House, and we can look at the Senate in just a second. And I'm totally just looking all this stuff up on the fly because we weren't originally planning on Ohio, but let's just roll with it. So let's see.
Scroll down.
Maybe Commerce, Labor, and Technology?
No.
Would it be judiciary?
Yes.
Okay.
Yes.
Okay, so there you go. And in just a second, we should.
It never, ever hurts to convince politicians, even if you're out for an administrative law change, it never hurts to convince politicians that your cause has merit. For example, I'm involved in a discussion on cell phone privacy, and that the issue at hand is whether carriers can sell your location information or give it away, or what protections it has. So they've been authorized by the Telecommunications Act to regulate this. And what exactly is regulated is kind of fuzzy, but they've recently gone through a reevaluation of this at the direction of the comedian who became a senator. Franken, yes. Al Franken's a huge privacy advocate, and so at his direction, the FCC opened a notice and comment period to reevaluate the rules regarding carrier proprietary network information.
So I'm guessing on the Ohio Senate, it's going to be the Criminal Justice Committee. But so here's your targets. Yeah, this is the Ohio House Chair of the Judiciary Committee. She's the Vice Chair. He's the ranking minority. So I guess Ohio's a very Republican state.
In the State House, yeah.
Yeah, and you
every chamber's
you can play people off of each other too, right? I mean, people get put on committees for a variety of reasons, and being any good at the topic at hand is not necessarily one of them. So there's a lot of personal politics that ends up getting played, which is part of why I hate this part.
Maybe this is just me, but I'm looking at the state court rules, which I've not looked at this way before, and I'm not sure that anything in Section 3 really applies, Section 3 really tells me I can't help my friends. It's got a whole bunch of regulations as to what an attorney has to do to be authorized to practice.
Right.
But I'm not.
Right. Well, it all kind of comes down to what is an attorney's practice. And an attorney's practice is advising.
But there should be clarity on this. I mean, people should know. People should know what the laws that govern them mean.
Yes, Bud. The world is part of the real problem with law is the world is a very, very complex place, and no two cases are exactly the same. There are a lot of cases that are very similar enough that it's pretty clear what side of the law you stand on, but not every one. That's you're close to the line there.
On the other hand, half the people's experience in law is going to be solely practice.
So have you found some cases where people any cases where people were actually like fined or convicted? Yeah, because I think that would be the next thing to look for is look for cases where people have actually been fined or been convicted of practicing law without a license for doing this. Yeah. And yes.
I did research on the ones about the front license plate. Because what I found in Ohio is that they keep changing that law, saying that yes, it is required to have the front license plate. No, it's not required, and they change it like on a monthly basis. And it's almost as if they just want to keep everyone on their toes so they can have an easy meal ticket.
Thanks,
Oh,
guys.
yeah.
Well, in Akron, it's not that big of an issue because nobody in Akron can actually pass the emissions test, so they all have pen tags anyway. It's true. In Connecticut, you actually have to pass the damn test, so.
Yeah, in California, you do too. They invented the test in California, though. So,
It does say that only the Supreme Court may make a determination that any person has committed the unauthorized practice of law in violation of Division A3.
I can't find anything in the rules yet that say, I can't just, it has all these rules that apply to attorneys.
right.
So what this is
Right.
Apply to some folks who are just
what this is telling me is that this might be an opportunity to be a test case if you want to be that guy.
Yeah, if you want to put yourself up for it. But
I've been a test case. I did not enjoy it.
yeah, it's not anyone's idea
It
of fun.
almost involved me getting extradited. It kind of sucked.
Not at all. You can always represent.
Yeah, you can
Yeah.
always go pro se.
Is that not considered practicing law?
No.
No.
Pro se is enshrined in the common law.
Many people just don't know how to do it and don't want
Yeah.
to learn. And it's,
Yeah, there are websites out there. One of the really interesting things about, the legal advice you hear on TV or on websites or anywhere else is this is just to give you a general idea. It is not, you should consult a lawyer to find out the facts of your specific instance. And that's the general disclaimer for we're not practicing law in this instance. The idea that you're giving general information, and that's how I work around. People come to me for advice all the time. The day I started law school, people started coming to me. And I was, my first year I was a lot more like, I started off, here's all the advice you want, and I didn't know shit. But then as I moved on, I realized, okay, this is a big deal. I can't tell them anything. And so, like, somebody came to me with a trademark question, and I'm like, I can't tell you, but I can tell you where to find the answer. And I was really kind of, I can't talk about this with you kind of attitude, but kind of taking a step back from that, it's like, in a general case, in order to claim a trademark date, you need to show that that trademark was in use on that date.
right.
Your case, you decide when you're, and show that that date happens, and so as long as you speak in general terms, as long as you make it really clear that you're not giving the keyword advice. Lawyers like keywords, advice. In this instance, you're giving guidance, making suggestions, that sort of stuff. But they have to make their own judgments.
The more I think
on
about it,
what
the more I
should
think
be
this is
done.
actually a really nice example of what does the rule of law really mean? I mean, mutual friends of ours have sat me down and said, Meredith, why are you wasting your time on this? Do you really even believe in the rule of law to start with? I'm like, well, it doesn't matter whether I do. It matters whether everyone else does. There's sort of this common widespread fallacy that law is anything other than just stuff we all agreed on. I mean, because that's what it is. I mean, and it's, in the case of statutory law, it's us by proxy. But then in the day-to-day implementation of the law, prosecutorial discretion is something that a lot of people have been complaining about because we see the choice of who to prosecute or who not to prosecute made primarily on the basis of whether the prosecutors think they can get a conviction and improve their career path or not, which is again perverse incentive set up by the way that the system is structured.
Yeah, that's inherent in the structure, and I can't see a way around that.
Yeah, but the question of whether anything is even going to go to court in the first place primarily rests on whether anybody bothers to prosecute it.
Yeah.
I mean, a good friend of mine's sister in Pennsylvania was dying of cancer back in 2008, and her husband at the time kidnapped their son, their 4-year-old kid. But this was Western Pennsylvania, very rural, and the district attorney didn't care. And we couldn't get him to pick up the case. We even tried to. Pennsylvania will allow people to file private criminal complaints, and we actually drafted one and submitted it, and it just got totally ignored. And this is a kidnapping we're talking about.
Well, they probably viewed it as a domestic dispute.
Yeah, that's exactly what they did. They said this is a
And-
domestic dispute. We're not domestic dispute. We're not getting involved. And we're like, there was a kid that has been kidnapped, and nobody knows where he is,
Right.
and they still didn't care. So, rule of law, no. Rule of what people can agree on.
Well, one of the things I realized long before I went to law school, I'd hear discussions with my friends, well, don't do that, that's illegal. Where it's not technically illegal to do what they were saying. Oh, people, I think it was safety at Noisebridge, and you can't let kids in an area where it might be unsafe. It's not illegal. There's no law that says you have to protect the safety of children that are not in your charge. There are protection laws, but not. And so the general public perception of the legality is something different than the actual legality. It's actually a tort to let kids get injured, but that's not a criminal problem, it's a civil problem. Yeah, questions?
Yeah.
Uh-huh.
He got that same runaround.
Yeah. Why don't you guys just hold on to
Yeah,
that?
hang on to that.
My dad got bit by the neighbor's dog and it broke his finger, and we called the dog warden or the warden, and they said, we don't handle it, you gotta call the statey. And call the statey, and the statey's like, we don't handle it, you gotta call the dog warden. And it just went back and forth, and nothing ever happened. And they pretty much told us that if we wanted to do anything, we'd have to take the homeowner where the dog was at to court and sue him,
Yes.
which would mean like suing some guy who's our friend, and this is just the guy who actually owns the dog is just some guy who's living there. It's like, it was totally worthless.
Well, if you should take the dog owner to court.
They told us we'd have to take the homeowner
That's
to court.
weird.
That's
Yeah.
really weird.
Well,
I think that's just wrong.
well,
but-
I think the reason they told you that is because homeowners have insurance, and you could get some money out of that, and renters.
We
more
can't
often
get
than
money out of that guy who's just living there with his girlfriend that has no job?
I think, see, there's this thing called judgment proof. People, it's, or squeezing blood out of a turnip.
Yeah, I mean,
if there's no money there, you can't get any money.
They sentenced Weave to pay $73,000 in restitution. I'm real curious where they think he's going to get that from.
Yeah, exactly. I know somebody who was convicted of anti-circumvention before anti-circumvention was a crime. And he was sentenced to pay hundreds of thousands of dollars, and he's perpetually judgment-proof. But then again, he'll never have a house. He'll never have a savings account because he's...
Well, hell, I mean, back during my my test case that I mentioned earlier, one of the things that happened during that was my sysadmin illegally transferred 3 years of my email to the prosecutors. Like, my sysadmin decided to fuck me over, basically, and handed over 3 years of my email, which was in violation of the Stored Communications Act and the Electronic Communications Privacy Act.
Well, it's arguable whether it, as the Stored Communication Act,
Well, at least
as it's written now.
in 2009, it was
Yeah.
it was illegal at
Yeah.
the time, and so we were easily able, on the basis of the SCA, the ECPA, and the Fourth Amendment, to get that subpoena quashed. So the prosecution was not allowed to use any of that material in trying to build their case. But the guy who actually broke the law, the guy who handed over the email, and for that matter, the prosecutor who illegally acquired it, both of them got off scot-free because we looked at the overall picture, and we were like, we could get 10 grand out of this guy, but does he even have 10 grand to give us?
Yeah.
So he doesn't have that felony conviction on his record now.
There's a different issue involved with, there's no private right of action for privacy violations. There's no private right of action for Fourth Amendment violations. The Fourth Amendment has no teeth in the civil world. because unless, and this is something, I was at a law school event where they were talking about the GPS tracking, and one of the speakers was somebody who worked for the district attorney who was the technical person who had issued a whole lot of these GPS trackers in San Jose. And he was saying, we'll still use them. We'll just use them as investigative tools, not for the conviction. Right. And so there is no civil teeth for the Fourth Amendment, which is really troublesome, because the Fourth Amendment doesn't just say in criminal procedures there's unreasonable search and seizures. In all circumstances, protection from unreasonable search and seizures. So it's not a criminal amendment. It's an all-purpose amendment, but it's only being enforced for criminal prosecutions.
So we've kind of wandered, so the Ohio issue was actually pretty easy. Do we want to try and tackle Nevada while we still got some time? Or
Our Nevada people
the Nevada
no
guy
longer
left.
here.
Okay.
Yeah.
Sorry, I've lost track of who everybody
Yeah.
was. Did anybody else have an issue that they wanted to start tackling right now? Because we got some time left. Okay. Do we have any other questions? Do you want to hear us ramble about funny law stories for the next 25 minutes?
Actually, we do need to reset the room to being a regular theater style.
Oh, yeah, that would probably be good, too.
Yeah, because I got Road Clown to help me reset.
Okay, so any other questions?
Okay, so I think
all right,
we're
well,
done.
thank you very much
Yes.
for coming. Thank you very much for providing examples for us to work with. That was a lot of
Yeah.
fun, and we're looking forward to having this actually all set up and automated with nice cross-referencing and full text indexing and stuff, so that you don't have to go to a billion different websites. You can just do it all in one place.
It'll be the second phase to bring in state law. Federal law is easy because it's across the board. Everybody has the same federal law, and it's a single source. It'll help us build a platform and test it, and address some very important issues that we all have. Like I'm really desperate for a reform of ECPA, Electronic Communications Privacy Act.
But we're looking to cover not just federal law, not just state law, but even international law. I live in Brussels, Belgium, and my housemate is a developer who hangs out with a bunch of university people there, and they're like, we want to get Belgian law into this, and I'm like, my God, that's going to be crazy, because the Belgian legal system is like a mishmash of like 5 different legal systems.
And it also raises the question of civil law as opposed to a common law. Here in the United States, we have a radically different legal system than, say, Belgium, or anything that is other than British, former British colonies.
Canada, Australia.
And India.
Oh.
Former British colonies, and there's some others like Macau, I think.
Yeah. So international law is weird.
Right,
but,
well,
yeah.
former British colonies have common law, which is law that is decided by the courts. Like most tort law, your dog bite problem, there's no law on the books that says if somebody has a dangerous animal, you can sue them for damages and potentially punitive damages for having this dangerous dog around. There's no law on any books anywhere, but everywhere you can sue them because we live in, and that's the way it's always been, so that's the way it will be. And so in human terms, common law makes a lot of sense, but in terms of knowing the law, it's really hard because, and that's part of the reason.
In Belgium, you don't sue somebody because their dog bit you. Like, people in Belgium don't sue each other. Like, that's not, it's just not a thing.
It's kind of an artifact of the common law system where you're not really reliant on the government so much for deciding what the law is. The only difference there is criminal law. You have to have notice that you can go to jail for something, for criminal violations. And so that the rest of the world has civil law, like people suing each other, or the government suing individuals for violations. Everything's codified there. So it's much easier to know what the law is in that situation, but it's much harder to exact change. Part of the problem with most technology law right now is that there's no tradition of this is the way we expect things to be. There's no reasonable expectation surrounding technology because there's no history, and there's no grounding in a common understanding like property law, what you own and how you give a gift. These are very well grounded in tradition. Like when I started studying property, we decided, or we learned that the beginning of time was the death of King Henry VIII. and so we actually went back to the old British common law as we picked it up here. And there's a lot of tie-ins specifically with torts and with property and other areas like that. So moving to Belgium, it's actually a little easier because it's not absolutely required that you look at the case law.
Yeah.
Because precedent isn't a thing.
We do have to handle 3 languages, but yeah.
Well, precedent isn't a thing. So one judicial interpretation is not binding on all the lower courts. It doesn't have the hierarchy that our court does. As an aside, kind of a common law explanation, the reason that a jury trial exists is because although lawyers study the books, the jury is there to interpret what people expect and what the culture is considering a realistic interpretation of the law or to begin with. So
Jury nullification goes back to British law too.
Right, and so the whole idea of the jury deciding what people's understanding of reasonableness and all these other, the law uses a lot of mishmash words that aren't very specific, but that's to give the jury a fair amount of leeway in deciding if our culture as it exists today in this locale, whether that really is what we think it is.
Yeah, because like the jury has the power. It's rarely able to exercise it these days because judges tend to, or because really like judges and attorneys tend to pick juries based on people not knowing about this. But the jury has a power called nullification, which basically boils down to he totally did it and we think that shouldn't be illegal.
Right.
Yeah, a jury can vote not guilty even though it's obvious that the person totally did it, if the jury thinks that the law should not be a law. In the U.S., this actually dates back to before the U.S. was the U.S. That was Zenger, right? Yeah.
They don't like to teach about jury
They
nullification.
do not like to teach
in law
about jury
school.
nullification, but one of the earliest, one of the most famous cases during the colonial period was a free speech case where a newspaper publisher was put on trial for printing seditious things, and the jury said he totally did it, and we think that's not wrong.
Wouldn't the defense?
Hold on.
Wouldn't the defense lawyer be bringing that up for some things? I can understand why the judge wouldn't care for it and the prosecutor wouldn't care for it, but wouldn't the defense lawyer be bringing that up from time to time?
The rules of court prevent that.
Yeah. Yeah.
Yeah, you
Courts do not want you to know about this power.
Yeah, the judge doesn't want the jury, and I was talking about rules of court earlier. The judge sets up the rules of court. You can't tell a jury to ignore instructions they were given. That's actually contempt. So.
That said, I'd love to see a lawyer go to jail just to do that.
A lawyer wouldn't love to go to jail just to do that.
I don't want to put you on the spot, but can you think of any contemporary examples of jury nullification?
Most recently was the most recently that I can recall was actually, and you're going to hate this, but it was during the Civil Rights period.
So like
This jury nullification was widely used in the South to keep Jim Crow laws going, basically.
And that's where the 14th Amendment charges came in, where,
That's
yeah.
why there's federal civil rights laws,
yes, yes.
large part of it.
Because we don't believe, you forced us into making this law. We don't believe it should be enforced. So, yeah, there are, another thing if you like to browse law libraries is they have model jury instructions. So instructions on what juries can and cannot be told for various offenses, mostly because the prosecutor is shooting to hit, these lists of things, circumstances have been met, so he's guilty, and the defense attorney is trying to do the specific elements, or at least attack specific elements. So it kind of gets everybody on the same page as far as, yeah.
I'm sorry, I couldn't hear you very well.
She's got the
Try
microphone.
that in the mic.
Yeah.
All right, how can we have jury nullification and equal protection at the same time?
That is a really good question, and that's why people or cases are held at. You can make a 14th Amendment claim after you've had a trial. Also, there's an appeal where, first of all, the judge can overturn the jury's decision if there is not evidence to support the conclusion that the jury came to. Usually it's when it's a pretty cut and dry case and it's obvious that he did it and the jury does do that, the judge can go back and say, no, this is
I would not have been surprised to see like Texas versus Lawrence, which was the sodomy case that eventually eventually went up to SCOTUS and got most of the sodomy laws in the U.S. flipped.
Right.
That case, I would not have been real surprised to see that one like die at trial under jury nullification if it had been someplace other than Texas.
Right.
Like if that had happened in like Massachusetts, it would have never gone to SCOTUS. It would have.
Yeah, and so whenever a judge reverses the decision of a jury, then that's an automatic appeal, and so you can appeal it, and it can go back and forth. So jury nullifications, it's something judges don't like, lawyers don't like, and it's very rarely done. But if it's on an issue that is unpopular, it's being prosecuted on laws that nobody likes, and it's being it'll just die because that was just an overzealous prosecutor. So you don't hear about overzealous prosecutors that often. So really,
well, you're starting to hear about it more these days.
Well, yeah. So
you look like you have a question.
I have a lot of questions about law.
You had questions.
we were originally talking about legislation, but I kind of expanded it to the
topic of prosecutors and talk a little around government power, but prosecutors have the money behind them of the municipality, state, or federal government.
Right.
How do citizens nullify that imbalance of power when that power is used in a corrupt way?
That's a really hard question to answer.
Yeah, I mean, this is basically Lessig's thing these days.
Well, usually, not really, because Lessig is talking about politics. But usually that's done by donating money to a public interest organization like this. Most famous is the Southern Poverty Law Center.
Or to people's individual defense funds as well.
Right.
ACLU.
Right.
Although that said,
Yeah, totally.
Speaking of defense funds, though, now we've got whatever court it is that's that Barrett Brown is going to trial at. They're trying to seize the $20,000 that's been raised by his supporters for legal aid. Yeah, they're trying to seize that and use it to pay his public defender.
His drug proceeds. No. Oh, there's another one that was on the news this morning.
Did you know there was some kind of oil spill or something in Arkansas?
Yeah,
The
the
pipelines.
Keystone Pipeline split
Yeah.
open and dumped diluted bitumen all
Oh,
over
I
the
didn't
place.
realize it was in
Yeah.
Arkansas.
Yeah.
Okay.
Yeah, it wasn't actually oil, it was,
So the story, someone called into the Diane Rehm show this morning and said, oh, by the way, did you know that cops hired by Exxon wrote tickets to people on private property who were taking pictures of what was going on? And there's a no-fly zone over it. How do they get
I'd
away
heard
with
about
that?
the no-fly zone. I had not heard about the tickets.
The tickets, that's an interesting thing. It's the Exxon cops are probably, some states have private interest partnerships with enforcement entities. They're not technically law enforcement, they're private security. Licensed private security people.
Well, that said, NYPD rents itself out too. Like, there's a line item in their budget for,
Yeah.
for renting out cops.
Yeah, SFPD actually requires it for certain events. But at the state level, they also, that's kind of the reverse, where you have the private funded cops. They can't arrest anyone. They can't, there are really interesting limitations on what they can do, but they can, this is a violation of my personal interest, so it's effectively a tort or some other thing, and so it's a civil claim against you, which would be upheld in the court of law, because it's like a in lieu of suing you kind of thing. So they can, and it's a money fine.
You can do that with torts?
It usually is under special provisions for these licensed people. At ShmooCon, the burly rent-a-cop types who would, scary people, at the ShmooCon party, it was held at this nightclub that was in a really sketchy part of town. And so they tried to confiscate my lockpicks, and I'm kind of pissed off at that. But the idea, or they're deputized by law enforcement, but they're funded by the
private interest.
By the private interest. So it's kind of a weird public-private partnership to help increase the law enforcement potential of the state. And Arkansas is not a very wealthy state, which kind of says something about the whole Walmart.
So does something like that actually have any legal teeth, or is it just harassment value?
It does have legal teeth because of the authorization statute for the civil penalties. It's like you can get fined by the FCC. They can't send you to jail, but you can get fined by them. You can get fined by any authorized organization, and you can be forced to leave because it's private property, and private property rights can be enforced.
No, they were on their own private property.
Yeah, I thought they were on either
Public?
their own or another party's private property.
Yeah, I mean, like if you're at your house and you're taking pictures of like the diluted bitumen that's all over your front yard, like you should not be able to be fined for that. That's bullshit.
Right. well, that would be a really interesting legal challenge, because that borders on First Amendment protections.
Yeah, and hopefully somebody does challenge
yeah,
that. I mean,
yeah.
again, we're talking about a tiny town in Arkansas where people probably don't have the money to fight this. But.
Part of it comes in the easement rights for the pipe.
Oh, the easement rights for the pipeline, right. Yeah, and easements are actually the part that go back to Henry VIII. But it's a hugely complicated problem with like telecommunications lines and pipelines and gas lines and all sorts of other things. There's
Roads, too.
You technically own the land, but they have permanent rights to that land, and that rights can come with all sorts of different protections, but those protections have to be stated at the time the easement was made, so they can't tack on more.
Well, I think the Constitution also counts too, right? Like.
Well, the net effect of an easement is that's an interest in property. So they have that interest in property, and so it's an interest in property is the same thing as property. You can buy and sell that, and you can pass it on, and but that's set up when the easement was set up. So if it's in the ability to photograph an easement on your property should be defined in the original easement agreement, and it's very, very unlikely that that was in there. It sounds like they're extending beyond their own property rights in trying to enforce that. So that is an interesting legal question that I can see, because they view that easement as their property.
Yeah, I mean, the next question I have is, well, let's go find that easement and see what those restrictions are.
But the other side of that is, I have a $20 million legal staff that I can go have them work on these issues, and I have a more, $80,000 mortgage on a $100,000 house and make $30,000 a year. How am I going to fight something like that? So that's what I was getting at with the harassment value, even though it has no legal standing.
Yeah, no, this is a social problem for sure.
And this is one of the things, all wonderful things about technology. To do the investigation on that easement, you have to go back to the Register of Deeds office and dig through the paper files to find the original easement and what the terms of that easement were. So you have to go dig through that easement registration with the state property boards.
Increasingly, states are putting that shit online.
Yes, and that's what makes it great for the common people, because you could go look at that easement if it were online, but you'd have to, if it's not online, then you have to go into the office and during business hours and go through and find the right book. Okay, here's the transfer of the easement, here's the transfer of the easement, here's the transfer, and go back and back and back and find the original easement stipulations and covenants.
So here's another interesting recent twist on that is, for the Keystone XL, I think it was, they were forcing people, taking people to court to force them, I think the Texas Railroad Commission, to grant them easements when they would not sell easements to the pipeline company under eminent domain, probably.
Yeah.
Well, eminent domain is just, it's ours now.
Yeah.
But that's a power of the state.
But you can do that for an
and I don't think the state.
too.
Well, I guess that happened in, was it New Hampshire or Connecticut?
The shoreline.
I know
you're talking
somebody
about?
who
There has been private property seized under eminent domain and sold off to corporations. It happened in
Yeah.
New England a couple
But
years
this
ago.
is
I know a situation where it happened. When I was living in St. Louis, I knew they were wanting to put in a Home Depot in a residential neighborhood. The reason that happens is, okay, the Home Depot came in and they bought out a bunch of houses, but not everyone would sell. And so they raised the price and bought out more houses, and they got 95% of the houses, but there were still some holdouts who were holding out for the cost of the project. And then the private interest got this government involved, and the government forced them to sell at the original buyout price. So the ultimate holdouts who were holding out for way too much, trying to protect their homes against this big box store, eventually lost out because of the interest of the larger project, which is kind of crazy, but it makes a little bit of sense if you think about they'd already invested, and it was one of the big arguments that I'm really tired, and this goes back to lawmaking, is every single argument for any technology law involves a number, and that number of jobs that this is creating. And it's like nobody cares about anything except the jobs, and it's all illusory anyway. These jobs would be somewhere else if they weren't with this company. And it also winds up, if for situations like the auto industry, you wind up with all your jobs in one company. So if that company goes stable or unstable, then it's another suck on the community to stabilize that poorly managed company, and so it undermines competition. So the whole jobs argument is nonsense.
Well, what I was getting at with the Keystone XL was, to what extent can they force you to accept terms like, you can't photograph anything on our pipeline from now on as
Well, it's
part of that
obviously
eminent
bounded by
domain
the Constitution.
proceeding?
Well,
or are they forced to
yeah.
only impose?
Finding constitutional issues in that is hard.
Right.
I think it's pretty clear
Well-
cut if you're
well-
talking about somebody's easement on your own property.
Well, they can't force additional terms on an easement. Once the easement is made, it's done.
Right, but this would be in the granting of in the forced
Yeah.
granting of the easement.
Right.
To what extent can they dictate terms that are unrelated directly to running a pipeline and maintaining it?
Those terms could probably be challenged.
Okay.
And
Yeah, I mean,
you would have to think.
they could presumably say something like, in the original easement, restrictions, they could put something on it like, all pipelines must be painted pink or something. Not really all that relevant to putting the pipeline.
Or
through.
you have to plant flowers over this easement.
Yeah.
There's,
I just want to check on, is Gina here for the next talk yet?
Okay, we'll continue.
we'll just keep going until the next top.
Will you just keep
totally.
going?
Yeah. Yeah.
And my recent pet peeve is all of these user agreements and license agreements that are coming out saying you indemnify and hold harmless. Now, it's one thing to hold harmless, but to indemnify and we get to pick the lawyers and you pay the bill, is that just directed at trying to put a lid on class action suits, these nuisance class action suits, or is there something more to that?
Yeah, the nuisance torts and the nuisance class action suits, that's typically why they're done. The idea is that, if you can resolve things without, the nuisance torts, then please do so.
People are just accepting these without even
Well,
thinking.
the most interesting thing I saw, I was reading one of my professor's blog posts recently about mutual privacy agreement. For this guy, he had a tooth problem. He went to a dentist who was on his plan's list of approved providers and got the tooth problem dealt with, but he was really unhappy with the service he got. And so he wrote bad reviews on Yelp and so forth. But as part of the service, he was given a document that was a mutual privacy agreement, where he said that he would keep his interactions with the dentist private, while the dentist wouldn't sell his information to third parties. So the dentist is required not to sell his information to third parties anyway, because of the whole HIPAA, Health Information Portability Protection Act. Or Portability and Accountability Act. So they couldn't sell it anyway. And so when he was really unhappy with the service and put the bad Yelp reviews up, she sued him. And for $100 a day, and Yelp wouldn't take it down because they believe that's bullshit. And so it's in the courts right now. But the idea, because she's claiming copyright violations, because he signed away his rights to write about her when he agreed to, or when he went to get service. Yeah. Next
All right.
speaker's up, yes.
All right.
Yeah.
Is there anything out there to protect people from companies writing such extravagant terms and services? Because I go through those every day, just accept whatever, go on. I don't even read them.
If you looked at the Hotmail terms of service in 2005, I think the answer to that is absolutely not. There's nothing limiting that.
So you can sign away your firstborn without even knowing
There's small. There's small bits in there, but limitations like you can't sell children because you can't sell children. But other than that, no. Well, there's this whole illegality thing. You can't agree to anything illegal in a contract.
I refuse to sign for some of the places I work for. They'll have it saying that if you develop anything while at work or with the company's property, they'll own the intellectual property on it. And I'm like, I
Yeah.
would decline to sign those because, well, for one, I already own intellectual property and I plan on doing more. And there's no way for them to prove or disprove that, yes, I did make it with their equipment or no, I did not. So,
Yeah.
and usually they're
Well,
pretty
that's
cool
actually
with it.
pretty standard contract for people who do work.
Information
If-
is power here.
Yeah.
I mean, knowing what
If-
knowing what you can and
I would
can't
explain it to
do.
them and then say I'm not signing it and they're okay with it.
If you have an agreement, the good way to do it is to have a rider that details all your unlicensed as yet intellectual property or unpublished intellectual property, so they know what's already yours and they don't take that, or they can't make claims against that. Making a claim against somebody's work is hard. They need to show that it was done on their computers, not the opposite.
Okay.
So, so that's really standard. But then again, as an aside, lawyers will never sign those. It's really interesting, largely because interactions between clients and lawyers are privileged, and so that's a special protection. And also, lawyers' work product has other protections. And then on top of that, the published work product has public, or is all public domain, because once it's been issued or sent to the courts have to public domain it. Otherwise, they can't make the precedent known. So,
You can just search my name and you'll see my patent.
exactly, that's public domain.
And there's like 20 Chinese sites that try to sell it to you.
Of course.
Thank you much.
Thank you.